Attention seniors, right now, debt collectors are betting you'll pay first and ask questions later. They're counting on you to see an official envelope, feel that panic in your chest, and write a check before anyone explains your rights. Last week, a 71-year-old woman named Dorothy from Seattle, Washington called me in tears. She'd just sent $1,240 to a collections agency for a bill that wasn't even hers. The letter had legal terms. It mentioned court action. She was terrified someone would take her home. Dorothy isn't alone. She worked as a school administrator for 30 years. She balanced budgets and managed staff. But the people sending these bills know exactly how to make smart people feel powerless. That's the strategy. Confusion leads to fear. Fear leads to payment. And payment means they win. I'm a lawyer who spent over a decade protecting seniors from financial abuse. What I've learned will make you angry. The companies billing you are hoping you'll pay out of panic before you realize the law protects you. Today I'm showing you 6 bills that seniors get pressured to pay but legally don't owe. I'm giving you the exact language to use when someone demands money you don't have to give. You spent decades working. You paid every bill on time. You played by the rules. Now it's time you learned when the system is designed to take advantage of you. Before we go further, let me be direct with you. Thousands of people miss critical updates every month because they're not subscribed to this channel. They find out about their rights too late, after they've already paid, after the damage is done. Don't let that be you. Hit the subscribe button right now. This information could save you thousands, but only if you actually see the next video I post. Subscribe before we continue. Let's start with something that terrifies seniors more than almost anything. Surprise medical bills that appear weeks after you thought everything was covered. Thomas is 69 years old and lives in Charlotte, North Carolina. He went to his regular hospital for what he thought was routine blood work. His insurance card was on file. Everything seemed normal. Then 6 weeks later, a bill for $1,680 arrived in his mailbox. Thomas sat at his dining table staring at the charges. He didn't recognize half the medical codes listed. The bill said he'd been seen by a specialist he couldn't even remember meeting. He called his insurance company 3 times. Each time he got transferred to a different department. Nobody could explain why this wasn't covered. He felt stupid for not understanding. He felt scared his credit would be destroyed if he didn't pay immediately. Here's what they don't tell you. These surprise bills happen when you receive care from a doctor who's out of your insurance network, even though you're at an in-network hospital, or when a service gets billed under the wrong code, or when your insurance company and the hospital can't agree on payment. The hospital knows this is confusing. They're counting on that confusion, but federal law protects you in many of these situations. Under the No Surprises Act, you have rights. If you received emergency care, or if you went to an in-network facility and didn't knowingly agree to out-of-network charges, you often don't owe the full amount. Let me be clear, you don't owe it. Many of these bills contain billing errors, duplicate charges, or services you never received. One recent study showed that nearly 60% of hospital bills contain mistakes. You can fight this. Request an itemized bill that shows every single charge. Ask your insurance company to review the claim again. Dispute charges that don't make sense. And here's a powerful question to ask the billing department. Can you show me the signed document where I agreed to these out-of-network fees? Most of the time they can't. Research shows that over half of people who appeal medical bills get them reduced or canceled completely. If a bill like this lands on your table, take a breath. You have time to figure this out. You have legal protections, and you have every right to ask questions. You're not being difficult. You're protecting what you worked your entire life to earn. Now let me talk about a bill that arrives at your lowest moment. Debt collectors calling about money a deceased family member supposedly owed. 3 days after Patricia buried her husband of 48 years, her phone rang. The voice on the other end was cold and direct. "Ma'am, your husband's credit card has an outstanding balance of $4,890. We need to arrange payment today, or we'll be forced to take further action." Patricia's hands went numb. She could barely breathe. The funeral expenses had already drained their savings. Now someone was telling her she owed nearly $5,000 more. She whispered into the phone that she never signed anything for that card. The collector responded, "You were married to him. You're responsible." She hung up shaking and called me the next morning convinced she had no choice but to pay. This is financial abuse disguised as debt collection. These companies know you're grieving. They know you're exhausted and overwhelmed. They know you'll do anything to make the calls stop. And they're counting on you not knowing the law. But here's the truth. Unless your name is on the account as a co-signer or joint account holder, you are not legally responsible for a deceased person's debts. not as a spouse, not as a child, not as anyone. Collectors will try to blur that line. They'll send letters to the estate, but phrase them like you personally owe the money. They'll use your confusion and your grief against you. They'll pressure you into making even a small payment, which can sometimes be used to claim you accepted responsibility. But if you didn't sign for the debt, it's not yours. I once worked with a man named George from Indianapolis, Indiana. His sister had passed away from cancer. 2 months later, he started getting calls about her medical bills totaling over $11,000. He'd never co-signed anything. He wasn't on her accounts, but the collector kept saying, "Someone has to pay this." We asked one question: "Can you provide a signed document showing George agreed to pay these bills?" They couldn't. The call stopped within a week. Let me say this as clearly as I can. Grief should never come with a bill attached. You are allowed to mourn without being financially hunted. If a collector contacts you about a deceased person's debt, ask for written proof that you are legally obligated. If they can't show your signature on an original agreement, you don't owe anything. The Federal Trade Commission confirms this. Don't let anyone tell you otherwise. Quick pause. What state are you watching from? Drop your state name in the comments right now. Laws differ by state, and I need to know where my viewers are located. Your comment also helps this video reach more people who need this information. Take 5 seconds and comment your state below. It matters. Now let me talk about something that feels personal and uncomfortable. When someone you know claims you owe them money, but there's no written proof. Barbara is 73 and lives in Denver, Colorado. One afternoon, she got a text from a former neighbor she hadn't heard from in over a year. The message said, "Hi Barbara, just checking when you'll be paying back that $650 I loaned you during the pandemic. I really need it now." Barbara felt her stomach drop. She remembered the neighbor bringing groceries a few times when she couldn't leave the house. She remembered feeling grateful, but she never remembered agreeing this was a loan that needed to be repaid. There was no conversation about money, no terms discussed, no paperwork, just kindness that was now being reframed as a debt. This is where generosity gets weaponized. Seniors, especially women, are often targeted in these informal situations. A favor gets quietly redefined as a loan months or even years later. A helping hand becomes a bill, and the pressure comes with emotional manipulation. What will people think if you don't pay? Don't you remember how much I helped you? Here's the legal reality. If there's no written agreement, no signed document, and no clear terms, it's not legally enforceable. Now, I'm not saying you should ignore your conscience. If you genuinely borrowed money and agreed to repay it, that's a different conversation. But if someone brings up money long after the fact with no proof, no text, no email, no written note, then they carry the burden of proof. Not you. I helped a retired teacher named Richard in Portland, Oregon, who was being harassed by a former caregiver. The caregiver claimed Richard owed $920 in cash from 2 years earlier. No written agreement, no bank record, just pressure and threats to tell other people at their church. We asked for documentation. They had none. It ended immediately. From a legal standpoint, here's what matters. Verbal agreements are extremely difficult to enforce without documentation. Courts need dates, terms, and signatures. And no, feeling guilty is not a legally binding contract. If someone approaches you with this kind of claim, here's what to say. "I don't recall agreeing to a formal loan. I need time to review this and possibly speak with someone before I make any decisions." You have every right to pause, to protect yourself, and to demand proof before you hand over money based on someone else's version of events. Let me talk about a bill that follows you even after you've moved on. Utility charges from addresses you no longer live at. William is 74 and lives with his daughter in Jacksonville, Florida now. 4 months after leaving his apartment in Columbus, Ohio, he received a $619 electric bill for his old place. He'd already closed his account. He'd notified the landlord. He hadn't lived there in months, but now he was being told he owed for nearly 20 weeks of service. William called the utility company confused and frustrated. They said his account was never properly closed, that the electricity kept running, that he was still the account holder of record. He tried explaining he didn't live there anymore. They said it didn't matter. Pay the bill or it goes to collections. He felt trapped and ashamed. This happens constantly. Seniors downsize, move in with family, or transition to assisted living. Then weeks or months later, a utility bill arrives like a ghost from the past. Here's what you need to understand. If you no longer lived at that address and the service wasn't under your control, you are not legally responsible for it. Sometimes companies fail to process account closures correctly. Other times, a new tenant or landlord allows service to continue and hopes the former resident will just pay out of guilt or confusion. And yes, they often target seniors because seniors tend to pay bills without arguing, but that doesn't make it legal. I worked with a woman named Joyce from Milwaukee, Wisconsin, who got a $470 water bill from her old condo 6 weeks after moving into senior housing. When we demanded proof, the company couldn't provide meter readings, service dates, or even confirm her name was on the account during that time period. The bill was dropped the same week. Here's what you need to do if this happens. Request written documentation showing dates of service, meter readings, and the name on the account. Provide proof of your move-out date if you have it, like a lease termination or forwarding address form. And most importantly, never pay a bill just to avoid hassle. That payment can be seen as admitting you're responsible. Under consumer protection laws in most states, utility providers must verify charges before sending you to collections. You have every right to dispute in writing and demand an investigation. One calm question can end this. One firm request for proof can make the whole problem disappear, real quick. If you're getting value from this, hit the like button right now. The algorithm promotes videos with strong engagement. That means more seniors see this information before they make a costly mistake. It takes 2 seconds, like the video now, so others can find it. Now let me talk about a type of bill that confuses and frightens people more than almost anything. Old debts that collectors say you still owe from years ago. Nancy is 70 years old and lives in Austin, Texas. One morning, her phone rang, and a collector told her she owed $2,780 on a store credit card from 2012. She barely remembered having the card. She had no idea if the debt was even real. The collector's voice was firm. If you don't make arrangements today, we will move forward with legal action. Nancy felt her chest tighten. She didn't want to be sued. She didn't want her credit destroyed. She almost agreed to a payment plan right there on the phone. But then she called me, and I told her what I'm about to tell you. In most states, you cannot be sued for a debt once it's past the statute of limitations. For most credit card and medical debts, that's typically 3 to 6 years. That means the debt is legally expired. It's uncollectible through the courts. Collectors can still contact you. They can still ask for payment, but they cannot take you to court and win. The real danger comes when seniors make a small payment or even verbally acknowledge the debt. That action can restart the legal clock and give the collector a fresh timeline to sue you. These are called time-barred debts. The law recognizes they exist, but it also recognizes they're too old to enforce. I once helped a widow in Fort Worth, Texas, who was being threatened over a personal loan from 2008. The collector said things like, "We're monitoring your credit and this will be reported." But when we asked for written validation under the Fair Debt Collection Practices Act, they vanished. No lawsuit, no follow-up, nothing. If this happens to you, here's your action plan. Don't confirm anything over the phone. Ask them to send written proof of the debt, including the date it originated. Look up your state's statute of limitations online or call a legal aid office. If the debt is expired, you can tell them in writing that you're aware it's time-barred and you do not intend to pay. One pause before responding can protect everything you've worked for. Now let me talk about the most heartbreaking type of bill. The ones that aren't even real. Last fall, a 68-year-old woman named Carol from San Jose, California, opened a letter marked urgent payment required. It said she owed $570 for a home monitoring service she never ordered. There was an account number, a phone number for customer service, even her correct address printed at the top. It looked completely legitimate, but it was a scam. This is how fraud works now. The bills look official, the language sounds professional, the logos seem real, and their favorite targets are seniors who value responsibility and doing the right thing. The danger isn't just losing money, it's the self-doubt they create, the fear that maybe you did sign up and forgot, the worry that you're losing your memory or being irresponsible. Here's the legal truth. If you never signed up for a service, you don't owe anything. Period. Scammers use bits of public information like your name and address to make fake bills look real. And once you pay them once, they often keep sending more bills because they know you're an easy target. I always tell my clients to trust their instincts. If something feels wrong, don't rush. Ask yourself these questions. Did I ever sign anything with this company? Have I heard from them before today? Why are they asking for payment through gift cards, wire transfers, or prepaid debit cards? Legitimate companies don't demand strange payment methods. They don't threaten lawsuits without proper documentation. Here's a tip that works every time. Ask for their business license number and full legal company name, then look them up online. Check the Better Business Bureau, search for complaints. If you find nothing or only scam warnings, you've just avoided a trap. According to the Federal Trade Commission, seniors lose billions every year to fraudulent billing. But it doesn't have to include you. You have the right to ask questions, to delay payment, to verify before you act. You still have control. Think of someone who needs this information: a parent, a sibling, a neighbor, someone who could lose money without knowing their rights. Share this video with them right now. Text the link immediately. Don't wait until the end. Do it now while it's on your mind. This could save someone thousands. Let me bring everything together. Today we covered 6 types of bills seniors are pressured to pay but don't legally owe. Medical bills you can dispute under federal protections. Debts from deceased relatives that aren't your responsibility unless you co-signed. Informal loans with no written proof or enforceable terms. Utility bills from addresses you no longer occupy or control. Time-barred debts that are legally expired and can't be used to sue you. And scam bills designed to exploit your trust and good intentions. All of this is aimed at one goal: giving you back control. Because here's the truth. You grew up in a different world, a world where a handshake mattered and bills made sense. You weren't raised with robocalls, phishing scams, and pages of fine print. So if this feels overwhelming, it's not because you're not smart enough. It's because the system was built to confuse you. But you still have rights, you still have choices, and most importantly, you still have the power to say no. Here's exactly what I want you to do. Write these steps down. You don't have to do everything today, but start with step 1 this week. Ready? Let's go. Step 1. If you have a medical bill that doesn't add up, call the billing department and request a fully itemized statement. Ask them to explain every charge. Then ask if the No Surprises Act applies to your situation. If the care was emergency treatment or happened at an in-network facility, you may be protected. Don't pay until you've reviewed everything. This single call could save you $1,500 to $3,200. Step 2. If you're being contacted about a debt from someone who passed away, ask the collector to send written proof that you personally signed for the debt. If you didn't co-sign or aren't a joint account holder, you don't owe it. Tell them clearly, I need documentation showing my legal obligation. If they can't provide it, they must stop contacting you. Make this request in writing if possible. Step 3. If someone claims you owe them money from an informal agreement years ago, ask for proof in writing, a text message, an email, a signed note, anything with dates and terms. If they can't show documentation, you are not legally required to pay. Don't let guilt or pressure force you into handing over money without proof. Step 4. If you get a utility bill from a place you no longer live, dispute it immediately in writing. Request proof of the service dates, meter readings, and your name on the account during that period. Send your dispute certified mail so you have proof they received it. Most of these bills disappear once you demand accountability. Step 5. If a debt collector calls about an old debt, ask when the debt was originally created. Look up your state's statute of limitations on debt collection. If the debt is older than that time frame, it's legally expired. You can tell them in writing that you know it's time barred and you will not be paying. Do not make even a small payment or the clock can restart. Step 6. If you receive a bill for a service you never signed up for, stop and verify. Look up the company online, check for complaints or scam warnings. Call the company back using a phone number you find independently, not the one on the bill. If it feels suspicious, report it to the Federal Trade Commission at reportfraud.ftc.gov. Don't pay anything until you're certain it's legitimate. You don't have to fight these battles alone. You can contact a legal aid office in your area. You can report scams and abusive collectors to the FTC. You can ask for help from family or friends. But the first step is knowing you have the right to protect yourself. Here's what I want you to do next. If this video helped you, subscribe to this channel. I release videos like this every single week to help seniors cut through confusion and protect what's theirs. Share this with someone who's been pressured to pay a bill they didn't understand. Your story and your action could help someone else feel less alone. Thank you for watching. I'm here to help, and I'll see you in the next video. Important disclaimer. This video is educational only, not legal, financial, tax, or medical advice. Every situation differs, and laws vary by state. Debt collection rules, consumer protections, and statutes of limitations are subject to change and differ depending on where you live. Consult licensed professionals, attorneys, certified public accountants, financial advisors, or other qualified experts before making decisions based on this content. What works for one person may not work for another. This video does not create an attorney-client relationship.